Aye. Contrary, no. The ayes have it. The question now is that clauses 1 to 3 stand part. Charles Chevelle.
Thank you, Mr Chairman. Mr Chairman, in the debate tonight, we first of all dealt with the questions around Part 1. And as members on this side explained at the time, there are good things in Part 1. It is appropriate that somebody seeking to become part of a jury panel who in the preceding 5 years has been sentenced to home detention for more than 3 months should probably not be part of a jury. Somebody who has other restrictions that are dealt with in the part that I'm speaking to now, sir, shouldn't be able to be part of a jury, and because that is a sensible reform, Labor members have decided that that part of the bill should have their support. What we can't support, though, is the arbitrary extension of the discriminatory standard relating to jurors that has been traversed exhaustively in the debate, which Dennis O'Rourke has moved a supplementary order paper about, and whose history my colleague Leanne Dalzell traversed. She showed, I think, through a forensic examination of the various statutory provisions that that anachronistic provision dates back to the time that the House, back in 1993, decided that the Human Rights Act should provide a general standard for our laws, and that it shouldn't just be the case that somebody should be deemed to be likely to be incompetent or less competent simply because they reach a certain age. And I think a big disappointment for members on this side of the House is that this wasn't an opportunity that was taken by the government to bring the Juries Act into line with the rest of our laws, which don't contain arbitrary standards around age. We had a very good contribution from my colleague David Parker, who talked about the importance of keeping the jury pool representative, because the purpose of jury trials is so that we can have assured accused persons being tried by a jury of their peers. And he reminded the House that by 2027 there will be 1 million people in New Zealand over the age of 65. Sir, my father's old law firm held the Crown Warrant in Gisborne for years. I remember the Crown Solicitor telling me how hard it was to get people to serve on a jury. We are abetting a public policy faux pas here by extending that entitlement, or extending that problem, by really saying that anybody over the age of 65, 1 million people, 1 million of our fellow New Zealanders by 2027, simply have a right not to participate, to opt out of the jury system in situations where it's incredibly hard to fill a jury pool. Not only is that patronising to people over the age of 65, it's just stupid public policy. So we do regret that the House didn't see those arguments with favour. We don't think an arbitrary entitlement to exclude oneself from a jury just because one reaches a certain age is sensible public policy. In fact, it deprives the court system of wisdom that it would, I think, well be able to use. We have our criticisms of Part 2 as well, sir. I tried to set some of those out in my speech on that part. I'm sorry if the Minister found any of it patronising. That was absolutely not my intention. And I was glad that she did seek the advice of her officials and did respond. I think the problem is that the response was lacking. First of all, she said there was no need to make the misuse of jury information an offence because a Law Commission report back in 2001 had said that there wasn't really any case for great reforms to the information, the law relating to the information that could be discovered about jurors. Well, of course, the problem with that argument is that that was 2001. The abuse of the system that occurred, sir, in this particular case leading to this particular bill occurred 9 years later in 2010 and was the reason that this bill was, Mr. Chairman, that this bill was put forward. And so it's not an answer to say, oh, there was a Law Commission report 10 years ago. That said, there wasn't a case for change because there was no abuse or no evidence of abuse of the jury system. Therefore, the suggestion that it ought to be an offence to misuse jury information doesn't have any merit. There's just no logic in that argument. And I think the other problem with what the Minister said when she was on her feet before was, well, some of these people are murderers, so they wouldn't really pay any attention to criminal sanction around misuse of jury information. That, sir, is a sad argument. It basically is telling the House, well, we give up when it comes to particularly violent people. We won't try to subject them to the rule of law or to any particular sanction or penalty because we're just a bit scared that they might not pay any attention. I actually thought better of the Minister and expected better from her. I never thought I'd hear the argument that, oh, well, they're murderers, so they're too tough for the law under my supervision to deal with. That was effectively what she told the House. And the other problem, sir, with this legislation was again set out by my colleague Leanne Dalzell. That is the leisurely progress that the bill has had. We heard that the committee dealt with the issue with expedition between April and June 2010. That was immediately following the misuse of the juror information by the litigant in person. The Minister at the time sprang into action, referred legislation to the committee. The committee processed it quickly, heard evidence and reported back to the House. Then the legislation languished for 10 months, 12 months, however long it was, and nothing was done. And I'm afraid, sir, that gives the lie to any claim that the Minister might make to be concerned at all about the safety of one of the most precious elements of our court system, and that is the safety of jurors.
Mr. Chair.
The Honourable Judith Collins.
Mr. Chair, just to deal with a couple of the comments made this evening. In fact, actually, the